Students, welcome to the lecture number 12 of the Indian Contract Act 1872, which is a part of CA Foundation cum Clat lecture series sponsored by Sri Jendra Exon. I am your mentor Shekhar Gehlot. So, till now we have discussed different formats of a contract, different essentials of a contract, and the performance of a contract. Now we'll discuss about breach of a contract. Now, we have already discussed till now the anticipatory breach of the contract in the previous chapter. In this chapter, we'll discuss about the actual breach of the contract. In contrast to anticipated breach, it is a case of refusal to perform the promise on a scheduled date. The parties to a lawful contract are bound to perform their respective promises. But when one of the parties breaks the contract by refusing to perform his promise, he is said to have committed a breach. In that case, the other party to the contract obtains the right to action against the one who has refused to perform his promise. Okay, so in anticipated breach of contract, the case was that other party had in advance a notice. Okay, now suppose contract is going to be performed on 31st of December. The other party would have a notice in advance, let's say some date in November, that the other party is not going to perform the contract. But here it is that on actual date of performance on 31st of December, he will come to know that contract could not be performed. Okay, contract could not be performed. Now this is an actual breach of the contract which is happening on the date of the contract itself, not before the date of the contract. Now, actual breach of the contract may be committed in following manner. At the time when the performance of the contract is due. Okay. Now, we discuss it with the help of an example. A agrees to deliver 100 bags of sugar to be on 1st of February 2016. Okay, now the date of the performance is 1st of February 2016. On the same date, that is the date of delivery, he failed to supply 100 bags of sugar to B. This is actual breach of the contract. The breach has been committed by A at the time when performance becomes due. Okay, so had it been a case of anticipated breach of contract, the breach would have happened before 1st of February 2016, maybe somewhere in December 15 or January 16. But when it happens on the same date, it becomes the actual breach of the contract. During the performance of the contract. During the performance of the contract. Okay, sometimes a contract may be which is a long contract. It is not a contract which is to be performed on one single date. Okay, it may be a month long going contract or a contract going on for 1 year or more than a year, like construction of a railway line, construction of a metro, construction of a dam. These are ongoing projects. Okay, in these, anytime breach may happen during the performance of the contract. Actual breach of the contract also occurs when during the performance of the contract one party fails. Okay. Now one party fails or refuses to perform his obligation under it by express or implied act. By express or implied act. Now AB Corporation has taken a contract to construct a dam, suppose say somewhere in Karnataka. The other party is the Karnataka government. Now, how express or implied contracts could be, how the contract could be breached in express or implied act, we'll discuss with the help of an example. Okay, during the contract work, when it has already started, somehow the manager of AB Corps write to Karnataka government for not performing contract that I will no longer perform this contract. These are the difficulties. Okay, now this is an express breach of contract implied. Okay, implied would be AB Corp did not write it, okay, to the Karnataka government, but what AB Corp did, it left the site with all the machinery and the labor. Now, this is the breach of contract by an act. Okay, they are just performing breach of they are breaching a contract during performance by their implied by their behavior, by their actions. They are not talking, they are not expressly writing a letter. So this is an implied breach of contract. Now, what are the remedies for breach of contract? When Indian Contract Act provides you right to enter into a contract, it also provides you rights in case your contract is breached. Now, these are called remedies for breach of contract. Now, what are the remedies available? Remedies are five kinds: suit for damages, rescission of contract, suit for specific performance, suit for injunction, suit upon quantum merit. Okay, quantum merit. Now we'll discuss all these in brief. Suit for damages. The first category is suit for damages. What are damages? Let us understand. Compensation for loss or damage caused by breach of contract. Damages, the injury caused. Okay, that is injury caused to other party or the harm suffered due to breach of that contract. Injury may be economic. Mostly it is economic or physical as well. Okay, it may be physical as well or it may be economic. Okay, it may be to the goods, in relation to the goods as well. Now, Contract Act talks about compensation for loss or damage caused by a breach of contract. Compensation. Okay, now compensation means compensation means paying or payment in term of money, that you will pay him or the other party this much sum of money for committing breach of the contract. When a contract has been broken, the party who suffers by such a breach is entitled to receive from party who has broken the contract compensation for any loss. Compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach or which the parties knew when they made the contract to be likely result from the breach of it. Okay, now there are two type of compensation. Okay, damages which are actually suffered, or damages which were agreed upon in advance, that tomorrow if some party will break the contract or will refuse to perform the contract or his part of obligation, this much shall be the damages which the other party will suffer, and the breaching party shall compensate the other party. Such compensation is not to be given for any remote or indirect loss or damage sustained by reason of the breach. Okay, but this compensation cannot be given for any remote or indirect loss. Okay, remote loss, any remote loss. Okay, let's take an example. A Okay, now what happens? A enters into contract for the B for supplying grains. Now, in this case, B has to supply grains for the A. Now, in an economic transaction, what would happen? A will buy grains from the B on some rate, and then A will sell it further in the market after making some profit over it. Now, if B would have supplied the grains to A on that date, the market rate for the grains was 100 rupees kg. Okay, so A would have sold them for 100 rupees kg. Okay, but somehow A had arranged a person who was willing to purchase grains for 500 rupees per kg. That is a premium of 400 rupees on each kg. Okay, but B somehow breached the contract and did not supply the grains to A on the required date. Now A has suffered a damage, that is a reasonable damages of 100 rupees per kg. Okay, because that is the prevailing market rate on that particular day. But now A says you pay me 400 rupees per kg rate. Okay, why? Because I was getting 500 rupees kg. So deducting this 400 rupees extra you pay me for each kg. Now this is called a remote damage. Okay, remote damage or a special damage. Okay, this is the indirect loss. Okay, or a loss which is not reasonable. So this loss B is not entitled, B is not liable to pay for. This rate B will pay only for 100 rupees per kg. Okay, B will pay 100 rupees per kg. Or some international team was supposed to conduct an inspection on A's go down. Okay, go down and would have given a contract of 100 crore rupees to A if A could have shown them the quantity of the go down that particular day. But because B did not supply A grains that particular moment, that team was dissatisfied with A's supply, A's uh, A stock. Okay, so they did not give the contract of 100 crore rupees to A. Now A cannot take back this 100 crore rupees from B. Okay, because that is a remote damage or that is an indirect loss. Okay, that is indirect loss. It has nothing to do with the contract between A and B. A and B's contract is purely for supplying of grains, nothing else. Compensation for failure to discharge obligation resembling those created by contract. Okay, now we are talking about a compensation for failure to discharge obligation resembling those created by contract. Now we are not discussing situation which is a contract. We are discussing situations which are just like a contract, but actually there are no contract. These are called quasi contract. Okay, just like contract we have discussed in the previous slide, so you can always go back and check them. When an obligation resembling those created by contract has been incurred and has not been discharged, any person injured by the failure to discharge is entitled to receive the same compensation from the party in default as if such person had contracted to discharge it and had broken his contract. Now, these are the situations in which a person is standing in a capacity that as if there is a contract between the two parties, though there is in reality no contract. Let us discuss a case or an example. Okay, now what has happened in this situation? A has found a laptop in Delhi. It belongs to B. Who is B? B lives in Jaipur. So B was a person who was on a tour to Delhi. So when he was on tour to Delhi, he was a tourist. He left his laptop in Delhi or he lost it somewhere. But somehow B found it, and B, as a good human being, B contacted A somehow, and A asked him that you deliver the B asked him that you please come in Delhi and take collect a laptop. It is with me and this is his address. But A expressed his ineligibility to come to Delhi due to some reasons and requested B to come to Jaipur and deliver the laptop. Okay, so B went to the Jaipur and delivered the laptop. Now they are standing in the capacity of a contract, though there is no contract between these two people. They barely know each other. Okay, they have not seen each other's face even. They have just talked on telephones. So now it is a responsibility of responsibility of B to compensate A for his traveling expenses to the Jaipur, traveling, lodging, and some food expenses reasonable. Okay, say 3,000 4,000 rupees to A. Okay, to A. If he does not pay, then A can file a case against B for compensation. Okay, because this is a failure to discharge obligation resembling those created by a contract. Okay, this is a breach of quasi contract. Now, in estimating the loss or damage arising from a breach of contract, the means which existed for remedying the inconvenience caused by the non performance of contract must be taken into account. Okay, so now it says court will have to take into picture a lot of factors, okay, for committing the breach of the contract. Like in this case, court will take into account the travel distance between Jaipur and Delhi, the fare, a reasonable fare of a train or a car, petrol, and reasonable food or staying accommodation, etc. Okay. The Act in Section 73 has laid down the rules as to how the amount of compensation is to be determined. Okay, now Act says how. Act also tells court how to determine the compensation. Definitely, it is court who's going to determine the compensation. But how will court determine the compensation? Court will take its guidance from the Act, Section 73 of the Act. On the breach of the contract, the party who suffers from such a breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him by breach. Compensation can be claimed for any loss or damage which naturally arises in usual course of events. Okay, compensation can be claimed for loss or damage which naturally arises in the usual course of events. Naturally, not unnaturally. Okay, naturally, like in this case this is unnatural. When an international team is going to conduct an inspection, now that is not a natural event, that is an unnatural event, okay, or something extraordinary event. Usually in trades, people are supplying each other different things, and they do not even know whether someone is going to use it or resell it in the market, or some team is going to conduct an inspection, huh? So usual natural consequence is the rate prevailing in the market that day. That day the rate is 100 rupees per kg. But here the unnatural result, unnatural loss is 500 rupees per kg, or in other case it is 100 crore rupees contract is lost. Now no one is entitled to, no one is liable to compensate that, or no one is entitled to seek compensation for this unnatural loss. Okay. A compensation can also be claimed for any loss or damage which the party knew when they entered into contract as likely to result from the breach. Okay. Now in this case, it says a compensation can be claimed from the party who has committed the breach of contract for amount which the other party knew. The other party is the party who committed the breach. If the other party knew at the time of contract that if I commit the breach, this party is going to suffer this much loss. So if the other party knows that he is going to suffer this much loss, then he is liable to compensate. Okay. So suppose in this case, if this person knew that he has a buyer of 500 rupees per kg available, and he had informed him in advance that if you don't come and deliver, I will suffer this much particular loss, then in this case B could be made liable for compensating him at the rate of 500 rupees per kg, otherwise not. Okay, otherwise not. This is to say, special damages can be claimed only on a previous notice, but the party suffering from breach is bound to take reasonable steps to minimize the loss. Okay, but the party suffering breach is bound to take reasonable steps to minimize the loss. But it is not simply just because someone has committed the breach, he will be liable to compensate you for all the losses you have suffered, for all the direct or indirect, natural or unnatural losses you have suffered. No, the party must act on its own as well, in its own good faith as well, in order to prevent the damages which are occurring from such breach from happening. Now, now A has contracted B Limited. Okay, B Limited is a fireproofing solution providing company. A contracts B Limited for fireproofing his godown on 21st of December 2020. Okay, but somehow B Limited could not come on 21st of December 2020. Now what happened on 22nd December? Now, what happened on 22nd December 2020? A fire broke out in A's go down. Okay, 21st December 2020, he was supposed to get his go down fireproofed done by B Limited. Okay, he had supplied some money as well to the B Limited, but somehow B Limited could not come on the stipulated date. That is the date is 21st December 2020. So, what happened on 22nd December 2020? Next day, somehow there was a fire in the go down, but fire was escalated by unnecessarily kept. Okay, the go down was for the sugar. Okay, but somehow there were some cans of petrol and kerosene kept here and there in the go down without any purpose for them. Okay, now the fire is escalated. Okay, fire blazed more higher. It became more tense due to that oil kept there. So he suffered a loss, a great deal of loss. Now In this case, he cannot thrust all his loss suffered due to fire upon the B Limited. Okay, because he was also duty bound that when there's a breach by the other party, he should also not have kept those cans of petrol or kerosene or oil, inflammable oil, unnecessarily in his go down. Okay, he should have removed those things, but he did not do so. So when he suffered a damage, definitely the other party cannot be held liable for unnecessary damage which could have been avoided by A. Okay, so any avoidable damage will not be automatically put upon the other party. It will depend upon the case to case basis. No compensation is payable for any remote or indirect loss, like we have just discussed. Now we will deal about remedy by way of damages, okay, or kind of damages which a person can seek. Damages means I am seeking money from you. Okay. So what kind of damages, what kind of money, what kind of amount one party can claim from the other party who has committed the breach of contract? Remedy by way of damages is the most common remedy available to the injured party. This is also even the most common remedy. Why? Because no other remedy can assist you because now already breach has taken place. This entitles the injured party to recover compensation for the loss suffered by it due to breach of the contract from the party who causes the breach. Section 73 to 75 of the Contract Act incorporates the provision in this regard. The damages which may be awarded to the injured party may be out of the following kinds. Okay, now these are the categories or the kinds in which the damages could be awarded to the other, to the party who has suffered a breach. General or ordinary damages, special damages, vindictive or exemplary damages, nominal damages, damages for deterioration caused by delay or prefixed damages. So these are the categories. Now we'll deal with these categories. We'll understand these categories briefly. Ordinary damage. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties know when they made the contract to be likely the result of such breach. Such compensation is not to be given for any remote and indirect loss or damage sustained by reason of the breach, law laid down in Headley versus Baxendale. Okay, now we have already discussed this kind of loss. So, in summary, it says that you can take damages only for those losses which you suffered because of the natural consequence of the breach of the contract, or if the other party knew that upon the breach you shall suffer that much damage, not otherwise. And we have already discussed these things by example previously. Okay. Now, this is Hadley versus Baxendale. It's a classic case from which this particular dictum arose out. The crankshaft of P's flour mill had broken. Okay, now P has a flour mill. On that flour mill, they use some kind of machinery. It has a crankshaft. He gives it to D, a common carrier who promised to deliver it to foundry in 2 days where the new shaft was to be made. Okay, so he gave it to the someone who was supposed to deliver it to the foundry. Okay, within 2 days, the mill stopped working. Okay, meanwhile, the mill stopped working. Why? Because the crankshaft is damaged. D delayed the delivery of the crankshaft, so the mill remained idle for another 5 days. Okay, now D said he will deliver within 2 days, but he did not deliver for next 5 days. Okay, so next 5 days the mill could not work. P received the repaid crankshaft 7 days later than he would have otherwise received. Consequently, P sued D for damages not only for delay in the delivery of broken product, but also for loss of profit suffered by the mill for not having been worked. Okay, for not having been worked. So now he could not work for 7 days. 5 extra days the mill could not work. Okay, the court, the count. It is not the count. It is the court. The court held that P was entitled only to the ordinary damage and D was not liable for the loss of profits because the only information given by P to D was that the article to be carried was a broken shaft of a mill and it was not made known to them that delay would result in loss of profits. Okay, it was not told to the D. D did not know that such loss of profit would occur by not delivering the particular crankshaft on a given date. Okay, because usually mills have spare parts as well. So D had no occasion to believe that this is the only part the mill has and mill would not work if this crankshaft is not delivered. A agrees to sell to B bags of rice at 500 rupees per bag. Okay, this is the price. At rupees 500 per bag. Delivery to be given after 2 months. On the date of delivery, the price of the rice goes up to 5,500 rupees per bag. A refuses to deliver the bags to B. B can claim from A 500 as ordinary damage arising directly from the breach of contract. Okay, like we discussed in the earlier example, whatever is the prevailing market conditions, whatever are the economic conditions which are prevailing in the market, okay, that is the ordinary damage. So he can now definitely sue him for extra 500 rupees. Now we go to special damages, where a party to a contract receives a notice of special circumstances affecting the contract. Okay, he will be liable not only for the damages arising naturally and directly from the breach, but also for special damages. Now, someone has a notice that some special damages will happen. Suppose in the case of Hadley versus Baxendale, if the D was informed that if you do not deliver it, the mill shall remain suspended for next 5 days and will definitely incur loss of profits for 5 more days. Then they would have been made liable to compensate Hadley for these extra 5 days of non-working of the mill. Okay, that is a case of special damage awarding in cases when the other party already has a previous information. A delivered a machine to be a common carrier to be conveyed to A's mill without delay. A also informed B that his mill was stopped for want of the machine. B unreasonably delayed the delivery of the machine and in consequence A lost a profitable contract with the government. In this case, A is entitled to receive from B by way of compensation the average amount of profit which would have been made by running the mill during the period of delay. But he cannot recover the loss sustained due to the loss of government contract as A's contract was not brought to the notice of B. Okay, because A now this is a just re-illustration of Hadley versus Baxendale. Okay, now he is the common carrier is supposed to compensate A for loss caused due to for loss of average profits for the time the mill was non-functional due to the delay caused by B. But definitely B cannot be held liable for the loss of government contract like we discussed earlier. Vindictive or exemplary damages. These damages may be awarded into two cases only. Vindictive or exemplary damages means when you are taking extra damages, okay, extra damages or damage in such a case in which your ego has suffered. I mean, these are damages for satisfying the ego of someone else, okay, when someone's honor or reputation has suffered. Okay, like if a newspaper is publishing a false news about someone. Okay, definitely that man's reputation is socially damaged. So now he can seek damage for that loss caused to his reputation. These are vindictive or exemplary damages. For breach of promise to marry but it causes injury to his or her feelings. Okay, now suppose say someone promises that I will marry you and this and that, and later on he or she refuses to marry. In this case, he can take some damages. The damages will be determined by the court for causing hurt to somebody's feelings, or for wrongful dishonor by a banker of his customer's check. Okay, so wrongful dishonor of the, because banks are liable to honor the checks. This is a commitment on the banks that they will never dishonor a check unreasonably or without any reasons. So now, unreasonably, if a bank is dishonoring somebody's check, then he can definitely suffer commercial consequences because payments are very relevant in the commercial market. Okay, in this case, the injury due to wrongful dishonor to the drawer of check is so heavy that it causes loss of credit and reputation to him, because even your civil score goes down and your reputation is also hurt when other party who has to take the check from you discovers that there are no funds in your account, and then they think bad of you. A businessman whose credit has suffered will get exemplary damages even if he has sustained no pecuniary loss, but a non-trader cannot get heavy damages in the like circumstances unless the damages are alleged and proved as special damages. Okay, a businessman, it is normally understood that a businessman man will definitely suffer a loss to reputation if his credit score goes down because of the default of the bank. But a normal person, definitely he is not a commercial person, he is a normal person, he is transacting between friends. His reputation will not be damaged because they know him thoroughly, they don't know him just as a commercial entity. So, a normal person will not get an exemplary damage for dishonoring of the check, but other person, a commercial trader will get exemplary damages for dishonoring of check. Why? Because it has caused a dent on his social reputation and his credit has gone down in the market. Okay, these are vindictive damages. No loss has been suffered, but definitely here a reputation is at stake and it goes down. This was held in the Gibbons versus Westminster Bank. Nominal damage. Nominal damages are awarded where the plaintiff has proved that there has been a breach of contract, but he has not in fact suffered any real damage. It is awarded just to establish the right to decree for the breach of contract. The amount may be 1 rupee, a rupee, or even 10 paisa. Okay, so amount may be, it is just a symbolic penalty imposed upon someone who has committed the breach of the contract, though the other party has not suffered any damage at all, but still because breach has happened he can claim compensation. This can be as low as 10 paisa or 1 rupee and may go high as well, depends upon the determination of the court in case to case basis. That is why it's called a nominal damage. Nominal damage means symbolic damages.
It's 5 o'clock.
Damages for deterioration caused by delay. Okay, in case of deterioration caused to goods by delay, damages can be recovered from carrier even without notice. The word deterioration not only implies physical damage to the goods, but it also means loss of special opportunity for sale. Okay, now sometimes what happens that you have to, one party says that I will supply you tomatoes by so and so date, but when the tomatoes were delivered, they were delivered in a deteriorated state, they were delivered in a bad state, they were stale, they were not fit for the consumption. Okay, Now, now everybody knows tomatoes are perishable commodity. That means it has a lifespan, very short shelf life, very short lifespan, and if not handled properly, they will definitely get damaged beyond repair. They cannot be repaired once damaged. Okay. Suppose the shelf life of a tomato is 5 days. He delivered the tomatoes in 9 days. Now, after 4 more days, definitely tomatoes have become stale. Okay, stale. Now they are stale. They are unfit for the consumption because their quality has gone down due to delay of 4 more days. Now here, now when B purchased the tomatoes, the rate of the tomato for purchase rate for tomato was 50 kg. Okay. But B was going to sell them at a market price. The market prevailing price is 80 rupees. Okay. Now, though the A purchased them for 50 rupees kg. So his damage he suffered is only for 50 rupees per kg into whatever amount of tomatoes are there. But here he will also get special damages because there was a loss of opportunity of sale. Definitely every trader has an opportunity of sale, and if the prevailing market of tomatoes was 80 rupees, definitely he could have sold them for 80 rupees that day. So now he has suffered a loss of 80 rupees. So instead of 50 rupees, the carrier or the one who is supposed to deliver the goods within reasonable time will now pay 80 rupees for the delay rather than 50 rupees. Prefixed damages which are previously fixed. Sometimes parties to a contract stipulate at time of its formation that on a breach of contract by any one of them a certain amount will be payable as damage. It may amount to be either liquidated damages as a reasonable estimate of likely loss in the case of a breach or a penalty, an amount arbitrarily fixed as the damages payable. Section 74 provides that if a sum is named in a contract as the amount to be paid in case of a breach, the aggrieved party is entitled to receive from the party at fault a reasonable compensation not exceeding the amount so named. Okay. Now prefix damages are, now suppose A enters into contract with the B that you do this thing for me on that particular date, and they, while entering into the contract, they mention this amount in the contract that if any of the party commits a breach, okay, the other party shall pay this much compensation, or they may put an interest that the party may pay compensation with an interest of 18%, okay, 20%, like this. Okay, so now when it is already mentioned in the contract, there is nothing left for the court to determine because both the parties had willingly agreed to suffer that loss in case of committing breach of the contract. Okay, that is a case of prefixed damages. If the penalty provided by the contract is 1 lakh and the actual loss of the breach is 70,000 only 70,000 shall be available as damages, the amount of actual loss and not the amount stipulated. But if the loss is say 1 lakh 50,000, then only 1 lakh shall be recoverable. Okay, so it is usually uh, the case with that if you have written 1 lakh and you have suffered a loss of 70,000, then you will get 70,000 plus something else like 80,000. But if you have suffered a loss of 1 lakh 50,000 and you have chosen to limit your compensation to 1 lakh, then court will not take it up. Court can bring down the compensation but will not usually take it higher. Penalty and liquidated damages. The parties to a contract may provide beforehand the amount of compensation payable In case of failure to perform the contract, in such cases, the question arises whether the courts will accept this figure as the measure of damage. Okay, now parties may write 1,50,000. In case of default, the question is whether the court will accept this 1,50,000 or not. Okay. According to the English law means law applicable in the Britain. The sum so fixed in the contract may be interpreted either as liquidated damages or a penalty clause. When you have prefixed damages, the clause we discussed as prefixed damages. In England, we call them liquidated damages or as penalty clause that you will suffer this much penalty for committing breach of the contract. If the sum fixed in the contract represents a genuine pre-estimate by parties of the loss, if the loss suffered is a genuine pre-estimate, okay, reasonable pre-estimate, which would be caused by a future breach of the contract, it is liquidated damages. If it is a genuine figure, then it is called a liquidated damages. If it is an assessment of the amount which, in opinion of the parties, will compensate for the breach, such a clause is effective and amount is recoverable. Okay, such clause is effective and this much amount can be recovered. But where sum fixed in the contract is unreasonable and is used to force the other party to perform the contract, it is a penalty. Such a clause is disregarded and the injured party cannot recover more than the actual loss. Okay. Now you cannot force someone to work for you. We cannot have a forced labor. Okay, because we do not follow slavery. No country in the world follows a slavery. So you cannot perpetuate slavery by entering unnecessary compensation in the contract so as to commit a threat upon the other party for those damages that if you will not perform the contract valuing 1 lakh rupees, we put in the contract that you will pay me 10 lakh rupees. That is highly unreasonable. Tomorrow if that party does not wish to work with you, the party has no choice but unnecessarily work with you as a slave, because now the other party is facing a threat of 10 lakh rupees loss on a work of 1 lakh rupees. So this can't be done. It has to be reasonable. If it is 90,000, 80,000, or 1 lakh, that is okay, but a penalty clause is not okay as per English law. Law applicable in Britain. And same is the position in India. Distinction between liquidated damages and penalty clause. What are the distinction or differences between liquidated damages and the penalty clause? Penalty and liquidated damages have one thing in common, that both are payable on the occurrence of a breach of contract. The commonality is that both are payable when some breach has happened. It is very difficult to draw a clear line of distinction between the two, but certain principles as laid down before may be helpful. If the sum payable is so large as to be far in excess of the probable damage on the breach, it is certainly a penalty. Okay. If the sum which is prefixed in the contract is far enough than the reasonable damage, it is called a penalty. Where the sum expressed to be payable on a certain date and a further sum in the event of default being made, the later sum is penalty because mere delay in the payment is unlikely to cause a damage. Okay. The expression used by the parties is not final. The court must find out whether the sum fixed in the contract is in truth a penalty or liquidated damages. Now the parties may choose to call it liquidated damages, but court will decide whether it's a liquidated damage or it is a penalty. Okay. If the sum fixed is extravagant or exorbitant, the courts will regard it as a penalty even if it is termed as liquidated damages in the contract. Okay, because court is not bound by the terms of the contract by the parties if the terms of the contract are opposed to public policy or opposed to the law laid down in the India. So when you go against the law and put down conditions in the contract, court is not bound to regard them. So if you are trying to cloth a penalty clause as a liquidated damages clause, court is not bound by that. The essence of a penalty is payment of money stipulated as a terrorum of offending party. The essence of liquidated damages is a genuine pre-estimate of the damage. Okay. It is terrorum. You are just trying to terrorize the offending party. By penalty clause, you are just trying to terrorize, create a threat, create an apprehension in the mind of offending party. The essence of liquidated damages, it's a genuine pre-estimate of the damage. It is a reasonable loss. English law makes a distinction between liquidated damage and penalty, but no such distinction is followed in India. The court in India must ascertain actual laws and award the same, which almost must not, however, exceed the sums of fixed in the contract. Okay. Besides claiming damages as a remedy for breach of contract, the following remedies are also available. Rescission of a contract. Rescission means withdrawing from a contract, refusing to perform. If the other party has refused to perform his part of the contract, you are also at liberty to not to perform your part of the contract. I enter into contract of sale with the seller for selling a mobile phone for rupees 1 lakh. Now he does not deliver me a mobile phone. I do not pay him. That's it. When a contract is broken by one party, the other party may treat the contract as rescinded. In such a case, he is absolved of all his obligations under the contract and is entitled to compensation for any damages that he might have suffered. A promises B to deliver 50 bags of cement on a certain day. B agrees to pay the amount on the receipt of goods. A failed to deliver the cement on a appointed day. B is discharged from his liability to pay the price. Okay, now he has no liability to pay the price, but also he can sue him for further damages. Okay, for the loss of business opportunity. Reasonable. Quantum merit, where one person has rendered services to another in circumstances which indicate an understanding between them that is to be paid for, although no particular remuneration has been fixed, the law will infer a promise to pay. Quantum merit, that is, as much as the party doing the service has deserved. Quantum merit is a Latin term which means whatever you have done, you shall be paid for it. It covers a case where the party injured by the breach had at the time of breach done part but not all the work which he is bound to do under the contract and seeks to be compensated for the value of work done. Okay, suppose I am contracted for constructing a four-story house. Okay, but after completion of two stories, the owner says, I do not want you to make further building. So at least you pay me for the construction of the two stories. You cannot say that because you have not completed the contract, I will not pay you at all. Okay, I have done construction of two stories, two floors. I shall be paid for those two floors. That is called quantum merit. Whatever work, quantum means quantity, merit means merit. Whatever meritable work I have done, I shall be paid for that. It is available only if the original contract is discharged. It is available when the original contract has been performed, okay, or discharged due to non performance or breached. The claim must be brought by a party not in default. Okay, the claim must not be brought by the party who has committed the default. Claim can be brought only by the party who has suffered default. Okay, so now if I run after the contract, run out of the contract myself, then I cannot claim quantum merit. Okay. The object of allowing a claim on quantum merit is to recompensate the party or person for value of the work which he has done. Damages are compensatory in nature while quantum merit is restitutory. It is but reasonable compensation awarded on implication of a contract to remunerate, where a person orders from a wine merchant 12 bottles of a whiskey and 2 of brandy and the purchaser accepts them. The purchaser must pay a reasonable price for the brandy. The claim for quantum merit arises in the following cases: when an agreement is discovered to be void or when a contract becomes void. Okay, now I enter into a contract with you for supplying of for export of onions. I have exported some onions, but later during half of the contract, the government says brings a law that there is no export of onion allowed in India now. So though now it has become void due to impossibility of performance as to be illegality, I shall be compensated for whatever onion I have supplied till date. You cannot refuse payment for that onion now by claiming it to be void. When something is done without any intention to do so gratuitously, when something is done without any intention to do it for free. Now, a milkman keeps a milk outside my house for 30 days and I consume it without saying even a word. Now, he comes and asks money from me. I cannot say that you never asked me for the money. If you have asked me for the money, I would not have taken your milk. Now, when you have consumed the milk, you cannot say so. When there is an express or implied contract to render services but there is no agreement as to remuneration. When there is an express contract, written contract, or a implied contract that you shall supply me your services but you have not decided any remuneration, salary, or the fees to be paid for that, then reasonable fees has to be paid. When one party abandons or refuses to perform the contract, okay, when one party has run away from the contract, the other party can claim quantum merit. Where a contract is divisible and the party not in default has enjoyed the benefit of the part performance, okay, where a contract is divisible, like I am to supposed to construct 4 floors but I have constructed only 2 floors. Now the other party, the owner, has run away and he has enjoyed 2 floors. Now he must pay for the 2 floors, okay. When an indivisible contract for a lump sum is completely performed but badly, the person who has performed the contract can claim the lump sum, but the other party can make a deduction for bad work. Okay, when something is done for the lump sum, like I'll do this, I'll construct a house for 1 crore rupees, but I've done it badly. Okay, so the other party can make some deductions. Other party can say, I'll pay you only 70 lakh. X wrongfully revoked Y his agent. Y's agent authority before Y could complete his duties. Held Y could recover as quantum merit for the work he had done and expenses he had incurred in the course of his duties as an agent. Okay. A agrees to deliver 100 bales of cotton to B at a price of 1000 rupees per bale. The cotton bales were to be delivered in 2 installments of 50 rupees each. A delivered the first installment but failed to supply the second. B must pay for the first delivery, first installment. That is, he must pay for the 50 bags. Sued for specific performance. Where damages are not adequate remedy in the case of a breach of contract, the court may in its discretion on a suit for specific performance direct party in breach to carry out his promise according to the terms of the contract. Okay, now I enter into contract for completion of 4-story building. After completing 2-story building, I run away from the contract. Then court can compel me to construct another 2-story building. Court can compel me. This is called specific performance. Court can direct me, you go and perform your part of the contract. You go and perform those 2 stories building other. You can construct 2 more floors there. You have to construct 4 floors totally. That is called specific performance. A singer enters into contract to appear in a concert and sing there, and then before the date he says I will not come. Court can say no, you have to come and sing because tickets have been sold out. Now you must appear and perform. That is called specific performance. Suit for injunction. Where a party to contract is negating the terms of contract, the court may by issuing an injunction order restrain him from doing what he promised not to do. And a film star agreed to act exclusively for a particular producer for 1 year. During the year she contracted to act for some other producer, held she could be restrained by an injunction. Suit for injunction means you stop someone from doing something. Okay, one actor contracted with the producer and took fees for exclusively working for him. Now he is also working for someone else. Now there can be an injunction. Court can direct the film star not to work for the other person because he has taken the advance payment for his full year's services. Now he cannot work for someone else. Okay, this is called injunction. So we are done with our contract law. Thank you.